while we were litigating those motions. And then after we get to litigate the motions and Commander Curran asserts that she's never met with them alone, we're sort of dumbfounded, and we go back to the SPCs, we initiate the contact, and they say, oh, that's actually incorrect information. At a minimum, that's just incredibly frustrating, and we think we've shown the relevance for any communications between these folks about this issue.
And I'm sure there's going to be lessons learned for all counsel based on that painful back and forth in litigation. So I'm ready to move on from that.
Yes, Your Honor. On request number 3, discovery or production of the original writings. Just one small note on that. So the government finished up with mentioning the possibility that date stamp 764 to 768, the letter that Ms. Wong has reviewed, from allegedly coming from EE, that it may have been destroyed. And that, you look surprised, Your Honor?
I do.
So, and Lieutenant Smith is certainly fair to correct me if I misunderstand it, but the government is suggested they've gone out and they asked that there's a possibility that letter, I guess maybe I won't use destroyed, but it doesn't exist anymore. The original doesn't exist.
It has been either lost or destroyed.
Lost or destroyed. And just the only thing the defense wants to throw in is that if that is the answer from the government, we want that in writing, in a filing, whatever, from the government, that document has been lost or destroyed.
Okay.
Number 4, which is related to Mr. Smith, and frankly, the request is related to defense funding requests for investigative travel. We've highlighted Mr. Smith, but obviously Lieutenant Brett and Lieutenant Phipps have evidenced in the record that they've taken investigative trips and that they've been harassed by the Deltas on their trips. So yeah.
Yeah, I'm just looking at Commander Ely. Is he okay?
Oh, yeah.
I'm fine, Your Honor.
Okay. But while we finish this motion, we'll take a break. All right. So can we? I'm tracking your motion, counsel. Okay. Is there anything else that you'd like to highlight?
I know it's tracking. I can't help but say that I'm frustrated by the government saying that our evidence is speculative. It is not speculative. We have produced evidence that the Dowdells knew Mr. Smith was going to be there. It's not speculative. So, a couple of things. One, when we, and I know this, right, as I'm traveling here today, when I have to travel to the Coast Guard, I have to send an email with my travel request, and it's to a, CG JAG travel, whatever, right? It's a group email. And I've opened it before, and there's a bunch of people in it. So I think the court ought to order the government to produce what we've requested for, and if they do an investigation or if they do their due diligence and determine that what we've requested doesn't exist, then we want that in writing. Again, the final line in the government's motion on this is, therefore, the government denies this discovery request as the defense has failed to meet the burden by establishing that some correspondence exists or is relevant. We definitely established that if it exists, it's relevant. And we've provided evidence suggesting that somebody told them. And it is a reasonable inference that it was somebody from the Coast Guard. Right? They're the only people that knew he was going to be there. So, one, the court ought to order the government to discover these emails, and if they do their homework and bust open that group email and find out who knew what, and the response is nobody knew about this contact of the Deldells, then they should put that in writing to us as their response, not what they've answered to us in that motion. On number 5, the production of the written correspondence between Roydell and Lieutenant Calhoun, I'll assert that we're requesting the court to order this, and it is not good enough based on the position of Lieutenant Callahan and Lieutenant Smith that the government just requests that these Lieutenant Callahan turn these over. That court, we're requesting for the court to order these. And government's like speaking from both sides of their mouth, saying, "Well, we don't think this is relevant, but we're going to request it anyway." Just 1 minute, yeah. Okay, that's all I have, yeah.
Okay. I will take into consideration the evidence in support of these motions, the arguments that were offered in the written motions in today's arguments, and I'll issue my written ruling. Incorporated in my previous order that I just granted about the motion to dismiss for discovery, trial counsel, incorporate the outstanding issues in your response due next Monday. Any responses that you've received regarding your actions for this motion to compel. Do you understand?
Sure. Could you just repeat that last bit? I couldn't hear the volume of your voice for that. You want me to incorporate
any responses that you've received? Any responses that you've received based on any steps you've taken regarding these discovery requests, you can incorporate that in your response next week in your email.
Understood, Your Honor. Will comply.
All right, thank you. All right. Counsel, I'd like to give a little bit of a break.
I was going to say, Your Honor, we're prepared to push, and we prefer to do that as long as the court's willing.
Okay, Commander, are you okay?
Yes, Your Honor.
You comfortable?
I actually suggested to counsel we continue on.
Okay, wonderful. All right, we will continue. I know eventually we're going to have a witness issue. I'm going to have to move Lieutenant Commander Barnum here and disinfect it, but I think that's in a couple motions, so we'll press forward. Okay, the next motion that we will take up is the defense motion in limine regarding the statements of Lori Dowdell. That is entered into the record as Appellate Exhibit 175. The government response is 176, and any ruling will be reserved for Appellate Exhibit 177. This was your motion, defense. Is there anything I can rule on here?
We believe so, Your Honor. That's why we made the motion without trying to be disrespectful, Your Honor. So there is obviously, if you look at the motions, there's a disagreement on who carries the burden here.
The proponent of the evidence carries the burden.
So the government says the defense is the moving party of the burden. I totally disagree.
I agree with that. I agree that the government has the burden. I just don't know what, any statement from Lori Dowdell. I don't know what evidence there is.
So, no, Your Honor. I mean, the motion is that the court make a pretrial ruling precluding Lori Dowdell from offering any inadmissible hearsay. So, the history in this case with the hearsay, specifically at one point, right, the government attempted to notify the defense of under MRE 807, but didn't provide any statements. And of course, we made a motion objecting to that, and the government withdrew it. So we sit here now on the 70 days, 75 days on the, sort of for us approaching the eve of trial in this long case, and we've yet to be presented with any further or new 807 notice. And
But that's not what we're talking about here. We're not talking about 807. We're not talking about residual hearsay, and that is withdrawn from the court. So if that came up under 807, that's the government's problem, right? I'm trying to answer. You've made a motion, you've taken the time, but I don't know what I can rule on. I keep hearing this 807 argument. But that's a different procedure, right? That has been withdrawn. So before me is inadmissible hearsay.
So we separated Lori Dowdell out of the other 6 witnesses, sort of. There's no doubt for us at this point on the other 6 witnesses that that the government has evidenced zero admissible testimony. We essentially feel the same way for Lori Dowdell. What she possesses is just a collection of hearsay statements, and we don't believe that she has admissible evidence. And so we think it's certainly upon the government to. They put her on our witness list, but we don't believe she has admissible evidence other than hearsay evidence. And to the extent they think she has admissible hearsay evidence, it's our position the government ought, as the proponent of the evidence, ought to put that forward.
Okay, thank you. Commander Tiley, are you anticipating trying to admit inadmissible hearsay through the testimony of Lori Dowdell?
No, Your Honor.
Are you prepared to, if there are out-of-court statements offered through Lori Dowdell, are you prepared to lay foundations of how those would be admissible under either a theory that it is not hearsay or a hearsay exception?
Yes, Your Honor. We intend to comply with all the rules established in Military Rule of Evidence 803 and 801.
Okay. I'm finding that, this issue right now, it is not ripe. There's nothing for me to rule on at this point. I don't think it's a wasted effort, defense counsel. Obviously, I appreciate everyone being on notice. I think I am on notice. Trial counsel's on notice. Defense is ready to argue the inadmissibility of these statements. When it goes to these evidentiary issues that will be outstanding at trial, what I appreciate is that we're trying to handle this before members. I am worried at trial of frequent Article 39As, and so defense, I appreciate the effort that you're attempting to make here. I just don't feel that I have something to rule on, a statement or whatever as she may say, right?
Yes, Your Honor. So certainly the the plethora of potential Article 39s are heading our way for this witness, but as we'll discuss in the next motion, the other 6 witnesses. But I'll stick to Lori Dowdell. That's one concern. The other concern is gamesmanship and preparing for trial. Right? We largely don't see admissible evidence from Lori Dowdell. She's not a witness to any of these charged offenses, and anything that she would have to say towards these offenses would be hearsay. So I'm baffled while she's on the witness list and looking for the government to say, well, these are the hearsay statements that are admissible. Because the position is that all she has is hearsay. It's all admissible.
Commander Tiley, I don't really need to hear anything else from you unless you have something else to add.
No, Your Honor. Thank you.
Okay, so I'm reserving ruling on these motions until I have evidence in front of me in which the government is attempting to admit through Lori Dowdell in the form of out-of-court statements that is either irrelevant or a violation of 801 and 802. At that time, I will rule on it. I would suggest trial counsel to be ready at a 39A before, if you plan on calling Ms. Dowdell, that will be the time that we have this, we litigate this motion.
Yes, Your Honor.
Okay.
I just want to clarify. I thought I heard you say motions. I'm still going to get a chance to speak to our.
Yeah, I'm just talking about this motion right now. Sorry, threw an additional S on that. Okay. Okay, moving on to the defense motion in limine to preclude testimony from potential government witnesses that is entered into the record as Appellate Exhibit 169. The government's reply is 170, and the court's written ruling would be reserved for Appellate Exhibit 171. Again, the proponent of the evidence would be who has the burden here. So I'll let trial counsel speak first. Trial counsel is based on your motion, I assume. It's the same argument that this is not ready for the court's ruling?
That's correct, Your Honor.
Okay, defense counsel?
So this motion is fundamental. So they have over 10 witnesses, right? These 6 witnesses, Lori Dagel, Emmy, Agent Nordstrom, Special Agent Nigro, and I'm probably missing a few others. This motion is primarily about gamesmanship and causing us to do a bunch of extra work that is totally unnecessary. There is zero evidence in the record that these 6 witnesses have any admissible testimony. They are all witnesses for which Emmy has made out-of-court statements that the government maybe would want to try and assert, to admit into the record for the truth of the matter asserted. It is classic hearsay. They have no admissible evidence. And the government, Your Honor, ought to force the government to ask the government to put forth what, if any, admissible evidence these 6 witnesses have, rather than cause the defense team to have to prepare for cross-examinations for 6 witnesses who have no admissible evidence.
Counsel, I'm having a hard time swallowing that this is gamesmanship. When the standard practice that you're familiar with is that the government needs to put all potential witnesses on their witness list, and that you have been litigating this case and you have been diligently, as the defense team, working this case for a long time. How this is gamesmanship on the government to throw you off the scent, I'm having a hard time picking up what you're putting down there.
So, Your Honor, I guess I would point to the government's response to our motion. I mean, if the suggestion or the idea is that these are, for instance, potential rebuttal witnesses, they didn't even bother to put that in their motion. They haven't. To me, that's further sign of potential gamesmanship. I mean, without actually accusing them of gamesmanship, but that's in line with what gamesmanship would be. We've made a motion on a good faith basis that they don't have any admissible evidence, and the government's response is just sort of like 401, 402, 403, and doesn't even suggest that they are the rebuttal witnesses or whatever, right? Because again, our position is they have no admissible evidence, certainly not on direct. Frankly, we don't think any of this was. Everything they would say would be hearsay. The government hasn't even gone so far to indicate that these maybe they're rebuttal witnesses.
Is there anything in the rules that require them to identify what type of witnesses they are to you?
What's up? Yeah. The defense required for our production, right? We've got to show.
That's for production, right? That's for production. That's how the rules are written. I'm asking you: is there anything in the rules that say that the government has to identify what flavor witness those are?
I certainly don't think it's fair play for the government to load the witness list up with a bunch of people that don't have admissible evidence, and then cause us to do a bunch of extra work. That would be fundamentally unfair.
Okay. And how many total witnesses are on their witness list?
Give me a minute, Your Honor.
Yeah, sure.
$13 witnesses for 4 charges, of which only 3 of them are witnesses to the alleged charges.
Okay. All right. Understood. Trial counsel, do you have anything to add?
Thank you, Your Honor.
Okay. There's nothing in front of me at this point that I can make a ruling of what you're asking me, counsel. I do not think 13 witnesses in a case as complex as this is shocks my conscience by any means, nor does it represent gamesmanship for the government on the government's part. But as far as your motion goes, I cannot make a ruling at this time, and I will reserve my ruling for this motion until the issue presents itself at trial. Okay. Let's take a 5-minute recess in place here. I'm just going to have to shift Lieutenant Commander Barnum. I'll ask Chief if we can just spray down the witness stand quickly. Right here. This court is in recess for health and comfort and to shift the courtroom. Let's aspire for 5 minutes. Carry on. Jeff, you get a second? Yeah. This court's called to order at 17:38 Eastern Time. All parties present in the court last recess are again present. Okay, counsel, by my count, we have 3 motions yet left to handle. The next motion in line is the defense motion. It is titled defense motion to pre-admit. It seems to be a defense motion in limine for the admissibility of recordings. That is entered into the record as Appellate Exhibit 197. The government response is Appellate Exhibit 198. The court's ruling is reserved for Appellate Exhibit 199. Defense is the proponent of the evidence. You agree you have the burden in this case, correct?
Yes, sir. And
I think this is what we're looking. So I believe you have one live witness. Is that correct?
Before we get started, to be clear, what we're looking for is to pre-admit these exhibits.
Okay. Do the rules allow me to pre-admit evidence before a panel is impaneled?
I believe they do, Your Honor.
Where? Let me ask you this. Doesn't jeopardy attach once evidence is submitted?
No, jeopardy attaches once a panel is impaneled, Your Honor, and then begins to hear evidence.
Okay. So we disagree on that.
Yeah, I think I'm not aware of any specific rule that doesn't allow us to pre-admit evidence. I've pre-admitted evidence in the past before selecting a jury.
I'm sure you have. So my read and my practice is that I'm happy to make a ruling on admissibility. We're really arguing about function and allowing you to, in good faith, argue admissibility, me to make a ruling that yes, this is admissible. You've laid the foundation. You don't have to do that at trial. But and with that ruling, I would think that would be good faith basis to argue at this evidence at opening, et cetera, et cetera. We're kind of splitting hairs here, but I am not going to go through the actual process of saying this is admitted into evidence. The words for identification will be struck.
I think I understand that, Your Honor. Candidly, yeah. I mean, we're looking for a ruling that allows us to craft our opening because this is evidence we'd like to use during our opening, obviously.
Yeah, and I think if the ruling is in your favor, then you can confidently say that you can use that in openings.
Yeah, I suppose what we'd be moving for then at trial is to actually have the exhibits admitted after impanelment before opening, so we could then use them.
Okay.
Understood, John. I also have one more item of documentary evidence for our appellate and closure list.
Okay.
I'll email this to the government. It's just the actual phone extraction report documenting the extraction of these 3 audio files. We'll mark that as enclosure KC and just add it to the record.
Okay.
And I give Your Honor a courtesy copy as well if you need that.
I don't need it today. If you can just, as you've been your practice, if you can just submit it with the court reporter.
We'll do, Your Honor. I'll likely be handing the witness a copy at some point during the authentication process.
Yep.
And the defense calls Mr. Kevin Smith.
Okay, very well. Mrs. Smith, let's get you sworn in. Trial counsel?
I apologize, Your Honor. I think I was on mute.
Yep.
Good afternoon, Mr. Smith. How are you?
Good afternoon. I'm good. How are you?
Good. Can you see me all right?
I can.
All right. You can hear me all right as well.
Roger that.
Great. Would you please raise your right hand? Do you swear or affirm the testimony you give in this matter now in hearing with the truth, the whole truth, and nothing but the truth, so help you God?
I do.
May lower your right hand and have a seat. Mr. Smith, would you just state your full name for the record?
It's got Kevin Smith.
Great.
Yes, absolutely.
Common spelling, sir?
Common spelling, yes, sir.
Great. And what is your current profession?
I am a defense litigation support specialist for Defense Service Office North.
Understood. And what is your current duty station, or you don't identify it as a duty station? What is your current city and state of residence?
Currently, Dumfries, Virginia.
Thank you, sir. Your Honor, those are all the preliminary questions that I have for you.
All right, very well. Lieutenant Phipps, your witness.
Thank you, Your Honor. Good evening, Mr. Smith.
Good evening.
Do you have any background in law enforcement?
I do.
Can you describe that background in law enforcement briefly?
Yes, prior to starting with the Navy's Defense Service, I concluded a 14-year law enforcement career, retiring as a special agent from the Department of Veterans Affairs.
During your 14-year law enforcement career, have you conducted any criminal investigations?
I have.
And during those criminal investigations, have you ever had to review electronic or digital evidence or extract digital evidence?
Yes, multiple times.
Have you had to review audio files during those investigations as well?
Yes.
And those audio files you've reviewed, have you had to rely upon your professional experience to determine whether or not the audio files you were listening to during investigations have been edited or tampered with?
Yes, that's one of the things we look at.
You also said you're currently a DLSS, a defense investigator. Do you perform investigations of criminal cases in that capacity?
I do.
Approximately how many investigations would you say you perform?
As a DLSS, probably, give or take, probably at least 20 plus general court-martial cases.
And without getting into the specifics of any privileged work you've done in that capacity, have you had to review audio recordings on that job?
Yes.
Analyze or look at digital evidence?
Yes.
What are some of the telltale signs you would expect to hear in an audio file that had been tampered with or edited?
So, if you're listening to an audio file, some obvious indicators would be a noise that's not that's new to the file, like a clicking or some type of a noise like that, or an immediate stop to the conversation and immediately picks up, but it hasn't flowed concurrently. So, those are some of the basic indicators, just listening to an audio file.
Have you taken any specific training in cellular device examination, forensic examination of cellular devices?
I have completed several different other trainings, but the most recent one, advanced smartphone forensics, and which incorporated cell-bright training, magnet, axiom, oxygen. Those are all forensic tools.
I want to turn your attention to a cell phone that you examined in this case back during the end of the summer. Do you recall being given a cell phone by the defense team to perform extraction on?
I do.
And whose cell phone was that?
Commander Elise.
And who directed you to examine that cell phone?
Yourself and Lieutenant Brett.
And what exactly did you do to examine that cell phone?
I took that cell phone. I was given access to the phone. I have a program, open source, if you will, program for extracting cell phone information. I took the phone while you all were at 39A and extracted the requested information.
Okay, so let's talk about the program you used. What was the name of that program?
It's called Re-Incubate iPhone Backup Extractor.
And is that a software tool?
It is a software program, yes.
Is that a reliable tool for extracting data from iPhones?
In my opinion, it is.
And how do you know that?
Did some open source research on it. It's used by the UK police, the Swedish police, the US Army, US Department of Justice, NASA. So I found that it was a pretty reliable tool. It was what we needed for what was requested.
And what exactly does this tool do in extracting data from iPhones?
So what it does is you hook up the device to the program. Once the program recognizes the device, acquires the device, you will be presented on the screen within the program different options of what's there to extract. And you can extract everything that's there available, or you can extract what you want.
Yes. You extract what you want. That extraction, does that create a forensic digital copy of whatever file you extracted on your computer platform?
It does.
And so in this case, which extraction method did you use to analyze this iPhone that you were given?
So I just did what we refer to as a logical extraction. I just hooked up the device to the program, let the program acquire it, and selected just the information that was requested.
And so what information did you actually select and extract?
The voice memo recordings from the device.
Okay. And did you then listen to those voice memo recordings that you extracted?
I did.
And what did you do with the phone? Did you keep the phone after you performed this extraction?
I did not. The phone was returned to the owner.
And do you know where it is now?
I do not.
So, I'll turn your attention now to what we've labeled defense exhibits Alpha through Charlie for identification. Did I have you listen to those before you testified today?
You did.
Before we get to that, did you also create essentially a forensic extraction report documenting what you extracted as part of your work?
I did.
And that's what I labeled enclosure KC just now, right?
I believe so, sir.
And just for ease of authentication, I'd like to provide a list of enclosure KC of the defense defense enclosures. I'll get the number off the top of my head.
Sure.
Thanks, sir. Just handed the witness enclosure Kilo Charlie. So the last page of that report, Mr. Smith, should have 3 files that you extracted from this item. Is that correct?
That's correct.
Okay, and when you extracted these files, did you also listen to those files?
I did.
And have you listened to them, again, these same files more recently?
I did last night.
Any difference in those files between when you first listened to them, when you first extracted them, and last night when you listened to them?
None whatsoever.
They're in the same condition?
Yes.
Sound exactly the same?
Yes.
Okay. So, the first file there is what we've marked as Defense Exhibit Alpha for identification. And so, can you just tell the court exactly what that file is?
It is a, we'd say, an MPEG-4 audio file. It was created on the 21st of January 2016 at 8:09 p.m.
And how are you able to tell when that file was created?
Because all the files that you extract that are on your phone has metadata similar to photos having EXIF data embedded into them, so you can look into the properties and see that data about the image or about the audio file.
Okay, so the metadata for Defense Exhibit Alpha identification tells you that file was created. What was the date again?
The 21st of January 2016.
And that metadata you look at, would that also be able to tell you whether or not a file had been digitally altered or modified?
There would be an indicator. That would be just one indicator. Obviously, having to listen to the file itself, but in looking at the properties, there is also in there a modification date. So, for instance, now on that file, there is a modification date of September 9th when I extracted it. That shows that that file has been removed from the device and that it was taken on this date.
Do you see any indicators that that file is being modified or altered digitally between its date of creation and you extracting it?
There was no modification dates listed on any of the files.
Any of the three files, Defense Exhibit Alpha through Charlie?
No, sir.
Now, looking at Defense Exhibit Alpha, you said this NAVTEC calls that an audio recording?
It is.
And how long was that audio recording?
That recording is 12 minutes and 32 seconds.
And you listened to all 12 minutes and 32 seconds?
Yes.
And based upon your professional background and experience as a law enforcement agent and an investigator, did you hear anything during your listen of that audio recording? Suppose you believe that audio recording had been tampered with?
No.
And which voices do you hear on that audio recording, Mr. Smith?
That recording is Commander Ely and Madison Ely.
Let's take this one at a time. How are you familiar with Commander Ely's voice?
I'm familiar with his voice from throughout this case of listening to a CJIS interview with Special Agent Nigro, as well as the polygraph examination with Special Agent Betts.
Okay, so that CJIS interview and that polygraph examination, those were videos the government provided for the defense team to discover, correct?
Yes.
And you could see Commander Ely on those videos?
Yes.
And hear his voice?
Yes.
And based upon your review of those videos, you're confident that you are familiar with Commander Ely's voice?
Yes.
How do you know what Madison's voice sounds like?
Similarly, throughout this case and discovery, there's some items, particularly two DCF forensic interviews. Previously I've watched those and saw her and listened to her.
Okay, so it was, again, the government provided the defense and discovery a video of a 2015 forensic interview
Yes.
and a 2016 forensic interview, right?
Yes.
And you saw Madison in both of those videos,
Yes.
and you heard her voice in both of those videos,
Yes.
and based upon your review of those items, you're confident you are familiar with Madison's voice.
Yes. Okay.
And based upon your familiarity with both Commander Ely's voice and Madison's voice, in your professional opinion, you're confident that those are the voices that we can hear in Defense Exhibit Alpha for identification?
I am.
Let's turn to Defense Exhibit Bravo for identification, the second file in that extraction report. Again, what did the metadata tell you that when that file was created?
That file also is a MPEG-4 audio file created on the 26th of October, 2016, and that was created at 5:45 p.m.
How long was that file?
And that file is 4 minutes and 47 seconds in length.
You already said that none of these three files have any digital indicators of being modified between creation and extracting them. Did you also listen to Defense Exhibit Bravo identification?
I did.
Audit?
Yes.
And your professional opinion, based upon your experience as a law enforcement agent and investigator, anything in that audio recording caused you to think that maybe it had been tampered or modified with,
No.
Objection, Your Honor.
Basis?
Your Honor, speculation. The expertise of this witness has not been established as to speculate on the reliability of the software being discussed.
Defense counsel, do you have a response?
I don't think this question was about software, Your Honor. It was about his review of an audio file and him listening to it and listening to that audio, whether his review, listening to that audio, based upon his experience as a criminal investigator for 14 years and then DLSS, whether he described some of these key indicators earlier on in his testimony.
So what I will consider is that his background as established, and that the recording did not contain any indications of tampering through his experience.
That's exactly the question I asked. The question I asked him as he's in out for a while, I think, Your Honor.
Yep. So your objection is overruled, trial counsel.
So again,
I think what you're trying is in his opinion. I don't want his opinion. I want facts of what he observed.
yes, sir.
Yep.
Based upon your review of the audio file and your experience, is there anything you heard in that audio file that would indicate whether it been edited or tampered with or modified?
No.
And which voices did you hear in your review of Defense Exhibit Bravo identification?
That was Madison Ely, Emily Ely, and Commander Ely.
We already discussed how you are familiar with Commander Ely's voice and Madison Ely's voice. How are you familiar with Emily Ely's voice?
Again, throughout the case and the review of discovery, there was a DCF interview of Emily. There's also audio of a CGIS interview, and there's also a recording of Emily and DCF worker Tim Curtis.
Okay, so to be clear, you've reviewed some videos that the government provided to defense of discovery in this case.
Yes.
One of them was a video of a forensic interview between Emily and DCF in 2016.
Yes.
And there was an audio of an interview with Emily and CGIS in 2017.
Yes.
And a video with Emily and Mr. Curtis from DCF in 2018.
Yes.
And you could see Emily in those two videos
Okay.
and hear her voice clearly.
Yes.
And based upon your review of that material, you're confident you're familiar with Emily's voice.
I am.
And based upon your familiarity with Emily's voice and Madison's voice and Commander Lee's voice, are you confident those are the three voices that you heard on Defense Exhibit Bravo identification?
I think I'm in trouble agreeing.
I just got indication from the court reporter that it appears Lieutenant Smith is having a hard time hearing. Lieutenant Smith, can you hear this line of inquiry?
Your Honor, I am having a difficult time trying to hold the phone closer and closer to my ear. I just have to Lieutenant to speak up at the end of the sentence, and he seems that he's kind of trailing off. That's the problem.
Okay.
I'm having difficulty.
Okay. Raise your hand if you can't hear it. All right, so we can rectify it. Okay, Lieutenant Phipps, go ahead.
Can you repeat my last question, Mr. Smith?
No, the answer was actually, if you would make sure I answer correctly.
Based upon your familiarity with Commander Ely's voice, with Madison Ely's voice, and Emily Ely's voice, are you confident the three voices you heard on Defense Exhibit Bravo identification belong to Commander Ely, Madison Ely, and Emily Ely?
Oh, I am.
Turning finally to the last recording on that extraction, was marked as Defense Exhibit Charlie for identification. What does the metadata tell you about when Defense Exhibit Charlie for identification was created?
file was created also on October 26, 2016 at 8:23 p.m. And
What kind of file is that?
it is a MPEG-4 audio.
What is the length of that audio file?
And it is 3 minutes and 56 seconds.
Did you listen to that audio file?
I did.
And during your review of that audio file, listening to it, is there anything that you heard that would indicate that that audio recording had been edited or tampered with since its creation?
There wasn't.
There was not.
There was not.
Which voices did you hear on Defense Exhibit Charlie for identification?
That was Madison Ely and Commander Ely.
And again, we discussed how you're familiar with Commander Ely's voice and Madison Ely's voice. So based upon your familiarity with those two voices, are you confident those are the two voices that you heard in that audio recording?
I am.
We've established, we need to establish to authenticate the recordings, Your Honor. Those are the questions I have on the authentication aspect.
Okay. Is there any other questions that you? Okay. I'll allow trial counsel to ask some questions.
Yes, sir.
Okay.
Great, thank you, Your Honor. Did you just turn it over to trial counsel?
I just turned it over to you, Lieutenant Smith. Go ahead.
Thank you, sir. Well, I guess good afternoon or good evening, Mr. Smith. I apologize also, Your Honor. Respectfully request permission to address the witness and also the court from a seated position based
Yeah.
on the kind of limited technology.
Absolutely. Please remain seated.
Thank you, Your Honor. So again, good afternoon, good evening, Mr. Smith. How are you?
Good. How are you?
Very good. All right, so I just have a couple questions based on your testimony with the defense counsel. First, you said that you based your reliability of the software off of a Google research or just kind of research that you did online on other organizations that use it.
I did.
Have you ever used the software before?
I have not.
This is the first time you've ever used the software?
It is.
Yes. I apologize. Sometimes the audio is cutting out, but I did see a head nod, so I think that was an affirmative response. Okay.
It was, sir.
And the second, sir, when you notice that these files are inside, I believe you said it was the voice memo file software or app.
Yes, sir.
Okay. When you notice those are in there, are you able to tell that audio file originated on the phone that it is currently on in that voice memo software, or is it unclear? I'm noticing something from the military judge. I don't know if this.
Yeah, Lieutenant Smith, what I'm doing is I'm moving the phone back from closer to the defense table now back closer to the witness table. Hopefully that helps you.
Oh, thank you, Your Honor. I appreciate it. So, Mr. Smith, let me just clarify that question. That was kind of a confusing question. When you notice that there is an audio file in this, voice memo app,
Okay.
are you able to determine based on the metadata that audio file that's in that voice memo app, that originated on that cell phone?
That it originated. That information it doesn't say.
Okay, so to ask it, I guess a little bit more simply, is it possible that one phone made the recording of this audio and then it was transferred to another phone before you were able to download it through the software that you just discussed previously?
I get to answer the question. It may be possible, but I don't think that it would be in a voice memo recording, if that makes sense. It would be more of you downloaded it to your device as a file, such as if somebody sent it to you in a text message.
I guess to ask a more definitive question, you can't be sure that the phone that you extracted this voice memo file was the same phone used to record that voice memo?
No.
Okay, so you do not. Okay, understood. Asked and answered. Thank you, sir. Other question, sir. Have you ever spoken to Emmy, the young girl with the initials Emmy? Have you spoken to her in person ever?
I have not.
And sir, I think it's an obvious question, but you were not in the room when this recording was made, correct?
No, I was not.
And you don't know anything that was said directly before the recording or the file began recording and saving the audio in the room, correct?
Objection. Relevance.
Overruled.
Can you say the question
I
again?
apologize, sir. I didn't hear the objection.
There was an objection. There was an objection on relevance. I overruled that objection, so you may ask the question.
Oh, thank you, Your Honor. So, Mr. Smith, again, you were not in the room when the audio recording was originally made, correct?
No, I was not.
Okay. So you have no idea what was said directly before Commander Ely, who allegedly made this recording, hit record, correct?
I do not.
Okay. And you have no idea what was said directly after the recording stopped?
Correct, I do not.
Just one moment, Your Honor. I'm just going to refer to the notes and just a moment, Mr. Smith.
Yes, sir.
I know this one. And the last question, Mr. Smith, when you say that you reviewed the recording that was made, that you are now, that the defense is now looking to admit into evidence, you were able to establish that that is an accurate representation of the recording that you originally found on the iPhone, correct?
Yes?
I think I heard a positive response. Yes, sir?
Yes, sir.
Okay. Great. Thank you, Mr. Smith. Those are all the questions I have.
Lieutenant Phipps, any follow-up?
Very briefly, Your Honor.
Sure.
I'm just discussing, it was the voice memo act you sent that you expected these files from, Mr. Smith, which is an iOS application, correct?
It is.
And this voice memo application has the ability to create audio files
It does.
and save audio files to that app, right? That are created within that app?
Yeah, it saves it to the device itself, yes.
You don't have the ability to use that app to import audio files not created with that app into that particular application, right?
Correct. Like I was explaining to Lieutenant Smith, I don't believe that you can create a recording. Somebody could send it to you as a text message per se, and you download it, and it would be now listed as your recording in your application.
So the files that you find in a voice memo application are files that are created by that application?
They are native to that device.
That's all the questions I have.
Okay. I don't have any further questions for Mr. Smith. Mr. Smith, thank you for your testimony. As you're well aware, please don't discuss your testimony with anyone other than counsel for the defense and counsel for the government, and you may step down. Thank you.
Thank you, sir.
Okay. Lieutenant Phipps?
Sir.
I'm ready to hear argument as to the admissibility.
Yes, sir. So, essentially what we're looking at when we're authenticating an item of evidence, right? Number one, is it what it purports to be? I'm going to take this off if you don't mind, sir.
Yeah, please.
Is the item of evidence what it purports to be? In this case, 3 audio recordings created on 3 select dates. So the first one created on the 21st of January 2016, containing the voices of Commander Ely and Madison Ely. The second created on the 26th of October 2016, containing the voices of Commander Ely, Madison Ely, and Emily Ely. And the third created on the 26th of October 2016, containing the voices of Commander Ely and Madison Ely. Are those what these Defense exhibits Alpha Fruit Charlie, authentication purport to be those things. Is there a reasonable, have we reasonably demonstrated that those are indeed those things, what they purport to be, and we have. Mr. Smith has just demonstrated that through the authentication process, that he recovered these specific files, used his experience investigating cases, used a specific application designed to recover these files, that he looked at the metadata associated with these files, that he listened to these files to determine they hadn't been corrupted or edited, that he recognized the voices on these files, and he could determine the date that these files were created. They are what they purport to be. They are these files. So the next question becomes...
Is there an issue under 901 that these recordings were made 4 years before they were extracted? And why not?
So the best evidence rule, Your Honor? Is that what we're talking about here? Or
just an authentication. Have you cleared that hurdle under 901 that it purports to be a recording?
I mean, we have here. I mean, they said authentication isn't an incredibly high hurdle. Now, this is the evidence that we have available. That was, again, forensically isolated. Right? We're not sending sort of files through email here. We actually took the pain to utilize an investigator to extract certain files and document his steps, and essentially generate sort of a custody document to that effect.
Okay.
So, yeah, it's files that he found on a device forensically and then created digital copies of, and you can establish when those files were created. So it doesn't create an issue as to authenticity, Your Honor.
Okay. So let's move to, I understand your argument, and I think you laid it out in your motion as well.
Yes, sir.
So let's move to the 400 series. Why is this evidence relevant?
Again, does it have any tendency to make a fact more or less likely than that fact would be without the evidence? And is that fact of consequence in determination of the action? What we're talking about here are 3 audio recordings from 2016, all featuring Madison, all during a period of time of charged conduct on the charge sheet where the government alleges that Madison is being sexually abused by her father. 3 recordings that demonstrate Madison has no concerns whatsoever about being sexually abused by her father. 3 recordings where Madison talks about her feelings, about her worries, and none of those worries are her father. It allows a finder of fact to conclude that it's more likely than not, based upon that evidence, or it has a tendency to make it more likely than not that Madison was not sexually abused by her father, directly negating a charge on the charge sheet, sir.
Okay, so these are out-of-court statements being offered for the truth of the matter asserted.
Yes, sir.
They meet the definition of hearsay. Under what hearsay exception would these statements be offered?
And we laid that out in our motion, Your Honor. We're talking
So present sense impression.
No, actually, present sense impression.
Yep. Go ahead. Go ahead, counsel.
Statement of then existing mental, emotional, or physical condition,
Yep.
Your Honor.
8033.
And specifically here, it's to do with her fear, her worries for the future. Again, Your Honor has, I don't know if Your Honor has, but Your Honor has the audio recordings,
Yep.
and you're free to listen to them. And predominantly, the predominant emotion that Madison's expressing through her words is her fear. Her fear of what will happen to her family in the future. Her fear of things that Mom is asking her to say, scary things that Mom is asking her to say about Dad, and she's also expressing her love of Dad as well. So 8033 is pretty squarely an exception that applies to these 3 recordings, Your Honor, and that's how we're offering.
Okay. That's all I have for you, counsel.
Thank you, sir.
Trial counsel?
Thank you, Your Honor. So the government's position is that proper foundation has not been laid. If there is no relevance to these statements, also they would violate the RCM 403 balancing test. The reason that the proper foundation has not been laid, Your Honor, is because they have not been established that this is a true and accurate representation of the conversation between Emmy and Commander Reed. The testimony given by the investigator, Mr. Smith, he admitted that he was not in the room. He doesn't know directly what was said before, what was said after. What was said before the phone button record was pressed would have a huge influence on whether or not what was said during the recording was an actual true and accurate representation of the way that Madison felt, in that heavily color that type of conversation. So knowing what happened directly before the audio between Commander Ely and me was recorded is very important to understand what a true and accurate representation of that conversation is. Mr. Smith could not give that foundational piece, therefore it is an improper foundation for the audio recording, so it should not be admitted.
Okay.
And Your Honor, that same line, I'll just touch on a couple other things. Additionally, the reliability of understanding how the software is used that peels these audio recordings off the phone, and then in terms of the fact that he's only used this recording once, and that the credibility of this software is simply backed up by a Google search. Again, not enough to properly lay the foundation for the quality of these audio files and the credibility of the audio files. Additionally, Your Honor, as discussed by Investigator Smith, he doesn't even know the actual recording was. As it was gone back and forth, Investigator Smith isn't certain whether or not a memo on this app could have originated on the app, could have been transferred. Maybe the phone's old, you transfer all the photos, memos, library pictures, things like that to a new phone. Those usually transfer one-to-one. Not knowing what type of device or being able to authenticate the device that made the recording, another important foundational step, again, not able to be testified to by Investigator Smith.
So counsel,
Your Honor, I believe I heard you.
Yep, I'm trying to ask a follow-on question. So, your concerns here, 901 is, defense is correct. 901 is not a rather high bar. Your concerns here seem to indicate concerns about the weight of the evidence, potentially. And so the defense has asked me to say, this is admissible, the foundation has been laid. The court could say that, yes, this is admissible, but I'm going to make you go through these steps at trial in front of the finders of fact. Is that something I should consider for the government to present evidence towards the weight?
Which is pretty long.
Your Honor, of course the government would want to be able to admit evidence towards the weight if Your Honor sees these foundational steps being met. But I guess the government is going to double down on the fact that even though this is a low bar, it has not been met. This is an individual who is not aware of the original recording, was not aware of the original conversation, is not aware of the context surrounding it. And while that can go to RCM 401, right, the relevance, or 403, the relative weight of this evidence, it goes to the foundation not even being able to establish that this is in fact a true and accurate representation of the conversation is a foundational element to being able to admit this. Investigator Smith, frankly, is just not the right person to be able to talk about laying the foundation for something that he does not have actual knowledge of. And that's the conversation.
Okay.
And to move on to RCM 401, we have an objection on that as well. The weight of this evidence is the type of evidence based on the inability to understand what happened before this conversation, what happened after the conversation that's recorded, makes it irrelevant. The panel members, the court, government, defense counsel, frankly, has no idea what was said before that recording began. Before that recording began, Commander Ely just said, we're gonna role play for a bit. We're gonna pretend Mom's a bad person. I don't know. I just think of something right off the bat like that. The fact that anything could have been said before that record button has been pressed, and then we hear this complete isolated conversation, which nobody who knows what was said before has testified in order to establish the relevance of that conversation in an isolated state, makes that piece of evidence so suspect that it becomes irrelevant. And certainly, even if it has a baseline relevance, it fails the 403 balancing test. Because the prejudicial value of members thinking that they understand the entire context of a conversation, of an original conversation between Commander Ely and his daughter, without any of the context before or after, certainly that prejudicial piece of it outweighs any probative value that it could offer. And additionally, Your Honor, what we effectively have is a witness who's authenticated that a recording is the same as a duplicate recording. No evidence by this witness has been presented to authenticate that the original conversation is the same as the first recording. All that was offered is that a recording that was made that was on a phone is the same as a duplicate recording made thereafter. Nothing has been spoken to as of the original conversation. And because this is the improper person to be able to lay the foundation for this conversation, and the recording, the original recording being an accurate representation of that original conversation, it's an improper foundation. The government objects on that. The government objects on 401. Again, the lack of value makes it irrelevant. Certainly in 403, and that the prejudicial value outweighs any probative value, substantially outweighs any probative value offered by this piece of evidence. And with that, Your Honor, pending any questions, that's the government's position.
No questions for you, Lieutenant Smith. Thank you. Lieutenant Phipps, I do have a question for you that I didn't ask you regarding the hearsay analysis. So we have statements from Madison. We also have statements from the accused as well during this recording, correct? So
Yes.
What's the theory of admissibility of his statements?
No, those statements are being offered for the truth of the matter asserted. I mean, they're statements of him reassuring his daughter. They're not statements of memory or belief or any facts we're attempting to prove up at court-martial.
Okay.
It's just a conversation with his daughter.
Your Honor, I apologize for interrupting. Asked that,
Yeah, so I'll summarize it. The defense counsel has stated that any statements by the accused are not being offered for the truth of the matter asserted. Essentially, they're being offered just simply for the effect on the listener.
Your Honor.
Okay. That's all I wanted to ask you, Lieutenant Phipps. You can respond to any other trial.
I'll keep it very brief, Your Honor. Sure. And the court has already identified this, which is trial counsel's arguments go to the weight, not the admissibility of the evidence. It really doesn't matter what was said before this recording or after this recording when it comes to admissibility. Sure, it may affect the weight. Maybe there's an argument, if supported by the evidence or a logical inference therefrom, the trial counsel can make about that, but that's got nothing to do with admissibility. And when it comes to authenticating an item of evidence this way, we've done that. We've reached that hurdle, and it's no different than when NCIS or CGIS do a drug sting and they take a suspect's phone and they extract voice recordings from that phone or pictures from that phone and authenticate those items of digital evidence for a jury, sir. We've easily hit those wickets, sir.
Would you like to respond to my question as far as an option that I have regarding, even if I say, yeah, I think you've made it, but I think the government should have the ability to present, cross-examination of Mr. Smith as they did today,
I would, sir.
In front of the members.
And two points I'd like to make on that issue. Number one, we're asking to pre-admit this item of evidence because, candidly, we want to use this during our opening statement. This is something we'd like the jury to be able to hear right after the government has said whatever they're going to say about Commander Ely to the members. We need that for a fair trial. Number two, just based upon the sequence of events at trial, I anticipate that the government will present their case first before we have a chance to call Mr. Smith. I will attempt to, and I will lay the foundation through Madison. I can do that with this item of evidence, and it will be excruciating, and the jury will hate it, and it will be prejudicial. But to get that evidence in, so the jury can hear it, that's where I'm going to have to do it, because we have no obligation to put on a case of our own. And so I'd like to avoid that. I'd like to avoid putting Madison through that particular trauma. So I laid the foundation here before we're even at trial, so that we can admit this piece of evidence.
Okay. All right. Thank you, counsel.
Yes, sir.
I will. I need to obviously listen to the recordings. I will do so, and I will issue a ruling on this at a later date. Okay. Counsel, we're down to our last two motions of the day. Is everyone still okay? All right, thumbs up from trial counsel and SVC's defense. You still okay? Okay. All right, the next motion that we are taking up is is the defense motion to dismiss for unreasonable multiplication of charges. That is entered into the record as Appellate Exhibit 191. The government response is 192. The court's ruling is reserved for one as Appellate Exhibit 193. Okay. Defense counsel, please talk to me. This is your motion, but please talk to me about good cause.
Your Honor, we rely on the evidence we offered in our written filing of good cause, and I would just add that this motion is again based on the first opportunity to review Commander Ely's recorded statement with Groton Police. This centers heavily around the accumulating evidence and the point that it's reached at this point in time that's overwhelmingly supportive of the fact that these allegations did not happen. And so that's how we have approached the remaining charges in this charge sheet. Obviously, we have watched this case devolve from 10 charges and specifications to what are now 4 charges and specifications. And it's taken every one of the days between pre-furl and today for us to assess the ever-evolving evidence in this case and research legal case law and precedent along the way to continue identifying new and evolving legal issues in this case.
So what new case law, counsel, for unreasonable multiplication of charges do you have?
Your Honor, I have not suggested there's new case law. I'm suggesting we are reassessing case law in light of newly evolving evidence. And a big portion of this motion is underscored by this interview with Groton Police that we now know Commander Ely never makes this false statement he was accused of making. And having an opportunity to review the circumstances of that interrogation, we now see that the government is trying to evade a vital element of the Article 107 offense.
Okay, so we're not talking preemption. We're talking UMC.
Correct. Yes, Your Honor. But that also furthered the concerns with the unreasonable multiplication of charges because it underscores the fact that the false official and the 134 and the remaining 120 charges are all premised now, all of them, the totality of these charges are premised on impermissible inferences and remarkably deteriorated evidence. In a case that started with a devoid recommendation to proceed to trial with no likelihood of success. And now the mounting evidence of his innocence requires us to seek additional relief from this court.
Counsel, I appreciate your veracity, and I'm not suggesting that everything you have done to this case has not been on the up and up, but I'm, again, having a similarly hard time under a motion for unreasonable multiplication of charges. I feel as though that you're using a UMC motion, which is a straight elements analysis, Kuros analysis that is seen in many a court-martials, to try to get the court to agree that you have a strong case. And add like another element to the Kuros analysis. I'm not trying to unnecessarily challenge you here, counsel, but I just am having a hard time understanding why this wasn't identified. We're on motion number, I don't know, close to 50 here. And the first time I'm seeing an unreasonable multiplication of charges motion is motion number 48.
Your Honor, and if I may, we have been attacking, obviously, this case from every angle with non-frivolous motions based on the evidence as it has evolved. And we began to spot these issues when we filed multiple motions to compel discovery. Because as we've repeatedly stated in this court, and exhaustively stated in this court, we must be missing evidence. And so we've been moving to compel. We've been moving this court to order the government to produce. They've been failing to comply with the court deadlines in this case. We've tried to address the deficiencies with the evidence through other motions, and now we have new evidence that we didn't previously have. And so I think it's...
And you have new evidence. What does that have to do with looking at the charge sheet and saying that these charges violate the Kuros analysis? Like, that is a straight charge sheet analysis.
Your Honor, we disagree that it's that facial. We do believe that, especially a UMC motion, the way that when we get to the merits of this motion, the way that I'm arguing it here is not based on what is, typically what we typically do when we talk about cure as factors when we're looking at facial charges. Do these criminalize one single act in unnecessarily multiplicious ways or unreasonably multiplicious ways? We're not making that accusation here. We're not making that argument here. We're asserting that as the evidence has presented, and it's taken every one of these last days since referral, this whole entire 12-month process, to realize the prosecutorial overreach in this case. And it's come to a head with the discovery of the fact that the false official statement Commander Ely was accused of making was never made. We did not have that evidence. I was not able to raise an argument like this at any time before this motions hearing. And as far as it applies to the Article 120 offenses, we now have striking new evidence of ME's continued deterioration that I was also unable to add to any earlier motion in this case.
Okay, so what I'm hearing from you, and what I've seen in other motions, that you feel that you have a very strong case as the defense. Okay, and I'm sure you do, but that's not a factor. Hey, the defense has a great case, I think, so therefore there's an unreasonable multiplication of charges.
Your Honor, we're asking you to consider prosecutorial overreach, and I'm prepared to make that argument, but I'm first trying to articulate the good cause for having filed this motion in accordance with the deadline that we requested to file this motion, as we continued to assess the evidence in this case. And the new evidence, and I think it's helpful to kind of walk through the remaining charges. 107 depends on an impermissible inference from the 120 charges that we have new evidence of that didn't exist at the last motions hearing. The 134 offense depends on the recorded interrogation that we now have access to with Broughton Police that now proves that Commander Ely never made the false statement he's accused of making. So we've just now, for the first time, had an opportunity to challenge the legality and the prosecutorial overreach by proceeding to trial at this juncture. I would assure the court that we are not here to just present motions to prove we have a strong case. We are here to identify legal errors and urge this court to provide relief. In a case that the government freely acknowledges depends on the highly compromised, demonstrably contaminated testimony of this little girl who is caught in the crossfire, who is actively hallucinating, who is actively medicated, and who has previously denied that these things happened. So we have an ethical duty now, for the first time, being able to see all 16,000 items of evidence in this case for the first time in full context to challenge the prosecutorial overreach in this case.
Okay, so let me hear from trial counsel briefly on the good cause issue.
Thank you. The government would argue that the defense's position on good cause for the UMC and the preemption is even weaker than for the other motions. Specifically on the UMC, and I know we'll talk to preemption after this, Your Honor, but these are, as Your Honor has indicated, motions based solely on the charge sheet. So the charge sheet was referred on May 16, 2019. The defense had every opportunity to raise this in the appropriate time after they had the bulk of the government's discovery, which was 6/4/2019, and prior to this court's order for the first round of motions, which was February 11, 2020. The defense had every opportunity to look at the charge sheet, make their analysis, and come up with this motion. And here we are in the fifth motion session, and they're coming back again with the motions that, just because apparently they didn't get around to doing, but that's not good cause. That's a cause, but certainly not good cause. And I would submit that this court should not hear these motions a year beyond the court's initial deadline.
Okay, since we're talking good cause, and trial counsel brought it up, I'm just going to finish the good cause analysis. Is somebody else arguing the preemption?
I am, Your Honor.
Okay, so can you, let's put them together, the good cause for preemption as well. And then,
Yes, Your Honor. And I want to correct a couple things because, and this should not be personal. It never should have been, but the government keeps mischaracterizing the state of the evidence and the evidence we have presented to this court to support every single motion and request for relief we've requested in this case. So first of all, The government must stop alleging that we were in possession of the bulk of this evidence in June of 2019. That is demonstrably false, and we've proven it. In 2019, we had about 1,300 pages and hidden files within files, which we now know contained this recorded interview that we could not access until 2020, and required the expert assistance of a discovery expert to review. And we've evidenced to the court that he only finished his work, the discovery expert, in October 2020. And that's why we're filing the motion at this juncture. So it is not true, and it is unfair to the defense in this case to suggest that we just got around to this. We have been working at an excruciating pace to keep up with the overly burdensome discovery in this case. And all the while, Your Honor, I would just remind the court that every time we have put in the record of trial the words effective preparation and cited the discovery issues, we have demonstrated the prejudice that has brought us to being able to argue this motion for the first time right now. When we flagged to the court back in March 2020, evidencing the memo of 9 March 2020, that we asked the government for help. Let us view these files that we cannot see, or else we are unable to effectively prepare, i.e. identify legal issues like this.
Talk to me about why, let's switch gears, and we have a preemption issue, or you're raising preemption.
Yes, sir. And the good cause is twofold, Your Honor, and I understand and I appreciate the court's questions, and I want to reply. So, again, the 107 charge is based on whatever happened in the article, whatever evidence supports the Article 120 offenses. And having the opportunity to assess those Article 120 offenses and the evidence that support it for the first time, and recognizing now for the first time, I apologize, the Article 134, I was confusing myself.
I'm tracking.
I want to walk backwards. So the Article 134 offense depends on whatever Commander Ely said in that interview. We didn't know what he said to make a preemption motion with the Article 107 offense until we saw what he said. We definitely saw, of course, facially from the charge sheet, it alleged a false official statement. But we did not know if they were evading a vital element of Article 107 because we were not sure of the circumstances of that recorded interrogation. And as we know today, the only evidence we had of that recorded interrogation was a false summary from Detective Nordstrom, who to this day refused to speak to us about that interrogation at an earlier stage of trial, and maintains that her summary is true, even though this court is going to see for yourself that the summary was inaccurate. It was false. So we had no way to challenge the fact that the government is indeed evading a vital element as is required by preemption. So we could not make a preemption claim before we reviewed the Article 134 evidence.
The 107 charge that is remaining.
And that's why I confused myself, Your Honor. We're challenging the 134 charge for preemption, not the 107. We're charging the 134 for being preempted by 107, but
yes,
but not this 107 charge here.
So that's where I'm confused, Counsel. You're saying that there is essential elements. I mean, the preemption analysis.
Well, if I may, Your Honor.
Is a congressional intent analysis followed by an elements analysis.
Yes, sir. But it does require a review of the facts to determine if it's preempted, because a review of whether the field is being occupied by a particular course of conduct requires a look of the course of conduct. So in this particular case, Article 107 only criminalizes false official statements when they are either in the line of duty or related to the line of duty or made to someone.
So 107 is not applicable to that. I get it. Even Officer Nordstrom was not acting in the line of duty. So it wouldn't have met the definition of an official statement.
And Your Honor, we didn't even learn that evidence until today when Lieutenant Phipps had the first opportunity to speak to her about whether she tried to involve the Coast Guard in that interrogation. We knew this was our last chance to make this motion. We knew when we watched that video for the first time, fall 2020, August, and had it converted. I apologize, I'm screwing up the month, so let me just stop there. But
okay, so here's what I'm going to do, Counsel. I'm reserving my ruling on good cause, and I'm going to hear these arguments for the other motions. So I want to hear your arguments on, let's now shift back to the UMC motion, and let's get into it.
Yes, sir. Addressing first the motion to dismiss for unreasonable multiplication of charges. As Your Honor already identified, this is not a typical Kuros factor analysis in that we are attacking unreasonably multiplicious charges. Rather, we're focusing on the Kuros analysis of prosecutorial overreach, even as it applies to a single specification. And we provided case law evidencing that even one single charge standing alone can represent prosecutorial overreach. This is supported by cases like United States v. Roderick, 62 MJ 425, and Kuros supports this contention, 55 MJ 339. These cases demonstrate that any abuse of prosecutorial discretion, whether multiplicity itself or multiplicity by over-criminalizing a single act, may be remedied by dismissal of the charge. And that's what we're asking for here. We have new evidence as we sit here today of Article 134 offense that we did not have at earlier stages of this trial to make this legal argument. And so we're making it now for the first time. And the unreasonable multiplication of this single charge over-criminalizes Commander Ely's conduct, even with that singular charge. Because in the Article 134 offense, he is accused of making a false official statement with the intent to obstruct justice. We now know that Investigator Nordstrom's summary of that interview, which was the only evidence we had of this charge for the last year, was false for a number of reasons. First, it was false because Commander Ely never made that statement. Secondly, he did not evade any of her questions and only tried excruciatingly to answer her questions. And third, that summary fails to evidence the fact that in that very interview, within the first 20 or 30 minutes of being in that room, he says, "Look, I'm having trouble remembering the events of this weekend. I know Aiden will talk to you. I'll make him come down here. Can I call him right now and I'll make him come here?" And he does. So the idea that Commander Ely acted to obstruct justice when he made a false statement we now know he didn't make, and we now know that he affirmatively assisted Groton Police and facilitated his son's arrival at the police station. And you're going to see in that interrogation, Commander, that Your Honor, that Aiden arrived during Commander Ely's interview. Commander Ely's interview terminated because his son complied with his order to come to the police station. The government has far over-criminalized and unfairly exposed Commander Ely to unjustifiable punishment by calling this an Article 134 obstruction of justice charge. And once we were able to review that same evidence, those same factual concerns gave rise to the preemption argument that we'll get to later. So as far as the Article 134 offense is concerned, it drastically and egregiously over-criminalizes the facts and the evidence of that charge. And not only that, but it unreasonably increases Commander Ely's punitive exposure because it will invite the members to watch what is now arguably an irrelevant interrogation because he does not obstruct justice in this interrogation. He does not make a false official statement in this investigation. You watch him call his son to participate with Groton PD in this investigation. And nevertheless, the government is still trying to present a facially prejudicial recorded interrogation of a senior Coast Guard officer sitting in an intimidating, dark, daunting room with a Groton police investigator and answering questions about yet another allegation of child sexual abuse. That is unfairly prejudicial in the face of evidence that this is a far overly criminalized single act. So we would ask this court to dismiss that charge. Turning now to the Article 120 offenses. The mounting evidence that has become available just as recently as this court's release of the MRE 513 records in this case demonstrates the profound concerns the defense has with Madison's credibility and her competence and what she may testify to at trial. But most importantly, it underscores the fact that the government is more willing to, and I say this respectfully but truthfully, parade a little girl in here to provide testimony in a federal courtroom about egregious allegations of child sexual abuse that may be disturbing to hear, but will be demonstrably false. And nobody in this courtroom cares about Madison Ely more than the people at this table, I can assure you. And with a full report that since 2019 has said there is no likelihood of success at trial, even before we learned of the forged handwritings, and before we learned of Lori Dowdell's hidden $45 million lawsuit for being disrespected by the Department of Children and Families, and before we learned that she was found culpable for encouraging her daughters to fabricate false allegations of child sexual abuse. Even before all that, this case had no likelihood of obtaining and sustaining a conviction. And now we sit here with an even further debilitated case with a child who is struggling to be well, who is obviously terrified of this trial, and obviously consumed by false fears that are only being fueled by whatever is happening in that house on a daily basis. Because we now have seen, and we've presented this evidence, that Madison is not improving the longer she's away from her father. She's getting worse. And at trial, we're going to present evidence of the fact that Madison's teachers, her medical records, her mental health records show she was thriving and happy and wanted to live with mom and dad, something Commander Ely encouraged. And now in 2020, the government's case lacks any DNA evidence, any physical evidence. We have finally resolved all these outstanding discovery issues where we were just waiting for something else to come. A bill of particulars, are we missing an interview? Is there a witness we haven't spoken to? What else is there? Because they cannot be resting this case on this poor little girl. And we have an ethical duty now to challenge the prosecutorial overreach at this juncture. And so, citing evidence of the new evidence that we've yielded in the course of the defense investigation, it's clear to us that there's no justifiable cause to proceed to trial at this point. It does two things. It exposes Commander Ely to grave and unfair punishment. It over-criminalizes what we're going to be able to show as something that never happened. And perhaps more importantly than all of that, it will traumatize. It will further traumatize. It will exacerbate the trauma that this little girl is already going through. Because God forbid she comes out of this one day and starts to ask for questions about the truth and realizes she testified against her father in a case like this. And so to go through all of that, not only with just the posture of the evidence, because I understand this is the defense point of view, but to go through all of that when the Department of Children and Families have found these things cannot be substantiated. Groton Police have found that they do not survive probable cause, and Lori Dowdell has coached an officer shopped. DCF has apparently more recently found that Lori did coach her daughters to make false allegations. You're going to put a little girl through, the government's going to put a little girl through that to be explained one day that the case wasn't successful for the Dowdells, or that they lost the case, or that a conviction wasn't sustained on appeal for factual sufficiency. And all of these reasons are red flags that I understand. Again, Your Honor, this is not a classical Curaz challenge, but it is a Curaz challenge. It is a challenge to the prosecutorial overreach as the evidence now sits today. It was weak in 2019, it is far weaker now, and it threatens the well-being of a little girl. So we invite the government to seriously consider the current posture of this case and what a trial will look like, and what the likelihood of an unsuccessful trial will feel like to a little girl like Madison in the middle of all this. And Your Honor, the 107 charge in this case rests solely on an impermissible inference of guilt and spillover for the Article 120 charge. So for there even to be a conviction on the Article 107 charge that Commander Ely must have been lying when he exhaustively participated with CJIS and insisted he did not sexually abuse his daughters, that can only be a finding of guilty if members believe the Article 120 offenses, because it's otherwise unsupported by any evidence. And it does depend solely on an improper spillover from the Article 120 charges. So, Your Honor, we realize this is a bit of a novel approach to Curaz, but we have an ethical duty to raise these issues and these concerns, and we respectfully ask this Court to seriously consider the prosecutorial overreach in this case based on the current, updated, evolved state of the evidence today, and dismiss the remaining charges and specifications in this case.
Okay. Thank you, Counsel.
Yes, sir.
Trial Counsel.
Did the court make a decision on the timeliness of this motion?
I said that I was reserving that ruling, and I wanted to hear our arguments since we're here, Counsel. If you'd like to rest on your motion, that's your prerogative, but I haven't made a decision whether there's good cause yet. I'm reserving that. But I wanted to hear arguments from counsel on the substantive part of the motion.
Yes, sir. Well, Your Honor, if I may.
Sure.
I would assert that good cause has not been met in this case.
What we just heard was essentially a closing argument, not an argument for UMC. When we look at, and actually I want to address one thing in particular, has continued to assert an allegation that there's been some type of finding that Ms. Dowdell has coached her children. That is just not true. The defense asked us to inquire into whether DTF had a record of that. There is no evidence of that. So to continue to reassert that is just not true. When we look at UMC, what potentially we have here, Your Honor, is the defense arguing that three specific charges regarding three distinct events on three distinct times and dates is somehow UMC. It is not. When we look at the Curic analysis, specifically from USC Juris 53NJ338, we see 5 questions. Did the accused object to an alleged unreasonable multiplication of charges timely? They did not. Once again, I assert that charges were referred on May 16, 2019. We're now over a year and a half away from that. This is our 5th motion session. This motion is untimely and should not be heard. When we look at the second prong, is the specification aimed at distinct separate acts? They are. We have an Article 107, we have an Article 2 specifications of Article 120, and an Article 134, all for distinct actions, distinct dates, distinct times. The third prong, does the number of specifications misrepresent the accused criminality? It does not. And once again, because we're talking about three distinct actions, three distinct charges across multiple time periods. Does the number of specifications unreasonably increase the punitive exposure? Again, it does not. The charging scheme does not misrepresent the accused criminal liability because the three remaining charges reference, again, three distinct allegations of criminal conduct across different time periods and different locations. Is there any evidence of prosecutorial overreach or abuse in the drafting? This case, again, is not a case of prosecutorial overreach. The government has broad discretion to conduct criminal prosecutions, including the power to select the charges to be brought in a particular case. Once again, I'll cite Paul, this is which is cited in our response, 47 U.S. at 859. Additionally, I would cite RCM 907B3B, which states that ordinarily a specification should not be dismissed for multiplicity before trial. Now, the defense has filed an untimely motion which should not be heard, and assuming that if the court does hear the motion, it should fail because it has not met the standard established in U.S. PQRs.
Understood. Thank you, trial counsel. Defense, do you have any response?
Just briefly, Your Honor. The government referenced the prosecutor's broad power to select charges and the way to bring charges forward, and that's exactly why the UMC motion exists. This is the only remedy that an accused has to challenge that discretion, to challenge the improper exercise of that discretion. And we've demonstrated prosecutorial overreach, and again, I already previewed this is not a typical Kuros analysis, but we addressed each of the Kuros factors in my written motion. Is each charge and specification aimed at separate acts? That doesn't apply here. We've already discussed that. Does the number of charges and specifications misrepresent or exaggerate the accused of criminality? This began as a 10-charge and specification case. We have now excised down to 4 charges and specifications based on either inadmissible evidence or witness inability or unwillingness to testify. Does the number of charges and specifications unfairly increase his punitive exposure? The evidence right now shows that these charges are not going to result in a conviction. And regardless of how strong we believe in our case, we are still taking a grave risk that a jury can get it wrong. And we see that they have. And that's exactly why Article 66 exists. But God forbid it come to that. That's a 2-year, multi-million-dollar process. In a case where right now in 2020 we know there was factual insufficiency even before trial. And I submit to Your Honor that we're filing this motion because this is not exercised often enough in cases like this to challenge the government's prosecutorial discretion in this case and the exercise of that discretion. And that's what this motion is centered around, the evidence of prosecutorial overreach. It's evidence in the fact that this came in here as a 10-charge case that largely painted Commander Ely as some kind of terrible person who must be a deviant and must have done something bad in all of this.
So how is that part of the analysis? I mean, you had a lot of charges, you have a lot less charges. So that's why we have cleansed charge sheets.
Yes, sir. And the court keeps bringing that up as something we should be grateful for. And certainly, we're always happy to go to trial with less charges, but that doesn't negate the fact that it's affirmative evidence that these charges were always drafted in an overreaching manner. This charge sheet was always overcharged. This case was always overcharged. And now we're down to the core allegations that this investigation was ever about in 2015 and 2016, and we now know a lot of new things that we didn't even know in 2019. We know that Commander Ely didn't obstruct justice when it came to his son's investigation, no matter how devastating those allegations were. And we know that Lori Dowdell is actively making a mockery of the Coast Guard by using the Coast Guard to further her $45 million lawsuit. Not for her daughters, under the very thinly veiled guise of being for her daughters. In her CJIS interview, her quote is, to Special Agent Langell, "I'm just hoping this is enough to file lawsuits. That's what you do when people disrespect you. You sue them." Those are her words. Those are her vengeful, selfish words. And within 2 years, the second she got the charges in the sheet, we don't know who in the government gave Lori Dowdell a copy of the charge sheet in this case, but she took it immediately to the state of Connecticut. She took it immediately to any agent who would look at it. And she didn't just say, open up the case again. Do something for my daughters. The Coast Guard is taking this seriously. She went knocking for $45 million. And the only new evidence of these allegations, since Groton police said that these allegations are not credible, and we find that the mother officer shops and coaches her daughters, and since the Department of Children and Families had to admonish Lori Dowdell from 2011 all the way through 2018 for improperly influencing her daughters. And according to the government says, there's no evidence that they made this finding against her. This is her claim in her lawsuit. We got this evidence from the government's witness, the evidence that she hid from the government. And so this isn't about, providing a closing argument. Trust me, we'd love to not preview that. But we're showing our cards in this case because this is not one of those cases. This is a case that deals with, presents a grave miscarriage of justice and threatens further traumatizing this little girl. And all the mental health records we see, these are, obviously relevant factors here for how this trial will proceed. Madison does not want to participate in this case. She's terrified of this case. She is obviously overwhelmed by the possibility of being dragged into this courtroom. So this is not a case where the complaining witness is driven to participate. Wants her day in court. She's devastated. She just wants to be normal, and you're going to hear that in her own words and the recordings that we provided to this court. Mommy says I'm not normal. Mommy wants me to say scary things that aren't true to you. Aren't true about you, Daddy. 15 days before they're going to yank me out of your arms, kicking and screaming to go live with Mommy for the next 4 years.
Okay, counsel. I'm tracking your arguments.
Yes, Your Honor, and I realize it got a little argumentative there, but I do want to circle back to the Kuros factors and the fact that it does specifically target prosecutorial overreach, and that's exactly where this case stands at this point, as an example of just that.
Understood. Okay. Again, I'm going to issue a written ruling. First, in that written ruling, there will be a determination of good cause, and if I determine good cause exists, then I will issue a written ruling on the substantive motion. The last motion we are going to discuss today is the defense motion to dismiss charge 5 for preemption. That's entered into the record as Appellate Exhibit 187. Government's response is 188. As with the UMC motion, I am reserving my ruling on good cause. Defense counsel, do you have anything additional to add to the preemption argument that is not either in your motion or that we've not just discussed with the UMC?
Well, Your Honor, I don't believe we've addressed the substantive piece of the preemption argument itself. Are you asking for the good cause?
No,
Okay.
good cause.
Yes, sir. Aside.
Right.
I would just add that it's our position, now having seen that Groton police interrogation from 2015, it's very clear now that the government is attempting to evade the vital element of 107 of proving that military nexus. And now we see that not only did he facilitate this investigation and he didn't provide a false official statement, but the government's avoiding having to prove that it was a false official statement related to a military duty or to a military office or to Officer Nordstrom in furtherance of a military investigation.
Okay, so this is the analysis the court would undertake under preemption analysis, right? So the first is that preemption depends on a showing of legislative intent to cover a class of offenses in a complete way, as well as a showing that the offense alleged under Article 134 is composed of a residuum of elements of an offense under another article. So that's the analysis under preemption. Do you have any evidence of legislative intent that Congress intended 107 to cover every untruth ever uttered by a military member?
No, Your Honor, but there has to be a military nexus. To
mean the element of an official statement. So if it doesn't,
he's charged with false official statement.
For
I apologize. False statement in the 134.
Obstruction of justice. That's what he's charged with.
Yes, sir. And when you look at the precedent cases, and I'm happy to supplement the motion with additional case law, Article 134 offenses that center around obstruction of justice do not involve false official statements unless they're made to civilian officials conducting a military investigation. And that's where the terminal element of 134 is met, because there's a service connection. Because in this event, had Commander Ely's son Aiden been a member of the Coast Guard, and had CJIS been attempting to initiate an investigation into these child sexual offenses, then perhaps there would be a military nexus. But of course, then they would have charged under 107.
So if a member out in town commits a crime off base, has no nexus to the military, but he's still an active duty member in the military's jurisdiction, and he gives a statement to the cops that obstructs justice.
Yes, Your Honor.
That doesn't meet the terminal element?
I could not find a case of Article 134 where an accused was charged for making a false statement to civilian investigators or to civilian law enforcement unrelated to a military investigation, or when he's not in uniform, or when he's not in furtherance of his duties, or when it was not likely to result in a military investigation. The 134 offenses that I was able to identify in case law did not criminalize this conduct outside of a military setting or in this course of military duty. And we weren't able to identify that as a missing piece of the facts here until we watched his interview. Because, of course, we had assumed, being unable to speak to Detective Nordstrom, unable to interview her until today in this court, Your Honor heard evidence. She admitted, I refuse to talk to you. I don't want to help you with your case. We don't want her help. We just want facts. And that's going to educate what we can do. And obviously we couldn't do that until today. And this was our last motions deadline to challenge legal errors related to the interview that we're just able to watch. And when we watched it, it became increasingly evident that there was not only no service connection, but they're evading the vital element.
I think we agree. We agree that it doesn't meet the definition of official statement. We're in agreement there. Where I don't think we're having a meeting of the minds is that the government is then precluded from going to Article 134 in charging that obstruction of justice when it doesn't meet the definition of an official statement. Because I don't see any evidence that Congress has intended on that.
Your Honor, I would just point to the plain language of Article 107 itself, which lays out the elements, and the purpose of the UCMJ is to criminalize offenses that have a direct effect on either good order and discipline or that are prejudicial to the service. And so Article 107 doesn't need that terminal element because it is an embedded element in Article 107. Therefore, Congress intended to criminalize any kind of conduct by a military member or with a military connection where a false statement was made. And in this case, the government knows there is no such military connection here, so they're attempting to squeeze it into an Article 134 offense, but still alleging a false statement when there's no military connection. And that's also why it's going to fail the terminal element of 134. So we're proceeding to trial in a case with two options here in our pocket. We've got preemption as defense, and we've got unreasonable multiplication of charges. And we've got an Article 134 offense that we know is not supported by the evidence in this case, and yet the government's going to be able to argue it anyway to unfairly paint Commander Ely as someone who must have been hiding something deviant about his son and another allegation of child sexual abuse. What a terrible, despicable family this must be. That's impermissible, and it's a charge unsupported by the evidence, preempted by Article 107, and that we would ask you to consider dismissing.
Okay. Thank you, counsel. Counsel.
Thank you, Your Honor. Again, the government would assert that, again, this is untimely. The defense had this charge sheet since May 16, 2019. For the preemption motion in particular, all they needed to do was look at the charges, and that should have been sufficient to come up with this motion. They failed to do so in a timely manner. Moving on from the timeliness of it, the defense is misapplying the rules regarding preemption, which are in place to prevent the government from using Article 134 to charge an accused with an offense already enumerated within the UCMJ. The charge, Article 134 obstruction, is not so closely aligned to the Article 107 offense as to make it preemptive. These are specific, again, elements. They are different. They are specifically charged for different conduct. This obstruction of justice under 134 is not the same as the Article 107. It is not they do not preempt each other. Further, the obstruction charge, as drafted, is consistent with and applicable to the charge as it was during the time period, which is at question, which is 2015. So it's not preempted with the new obstruction of justice, the obstruction charge, which is now Article 131 Bravo, as modified by the National Defense Authorization Act of 2016. Once again, Your Honor, this is untimely. It's simply just by looking at the charges, this does not meet the standard that the defense motion should fail.
Okay, trial counsel, the one thing I just want to, because I saw it in your motion, there was some reference to the 2016 MCM and the changes of that, but recognizing that this charge, the offense in Charge 5, occurred in 2015, so I'm looking at the charges as they were drafted and represented in the 2012 edition of the Manuals for Court Martial. Is that correct?
That's correct.
Okay. I want to make sure we're on the same page. Anything else to add?
No, Your Honor.
Okay, thank you, counsel. Okay, is there anything else to take up today on the record?
Yes, Your Honor, just a brief...
Thank you, Your Honor. There's nothing further from the government.
I apologize.
Yep.
We do have a brief oral motion based on, it's about the mental health records. And I won't get into the substance, so I don't think we need to seal. So the court did disclose, it's a motion to disclose the full, complete records. And we cite the fact that what the government provided, that the government let parties know that the court received over at least 1,000 records, mental health record, pages of mental health records, and that was just from the first 3 agencies. We understand the court went through a thorough analysis of those records for a constitutional assessment of what is required. What does due process require for the defense in this case? The court released 37 pages of very, very heavily redacted documents. And it's so redacted, in fact, Your Honor, that we're unable to even assess what dates some of these statements were made on and to whom some of these statements were made. And we can infer, kind of, that maybe some of these were from the same sessions, but that's not exactly clear, and that's not a reliable inference on our part. And so it's the defense's position that in order to make meaningful use of the kind of random sentences or statements that are not redacted among overwhelmingly redacted pages, 75-85% of these pages are redacted, we're not able to make effective use of them as the Constitution does require without seeing them in full context. So we just move this court to disclose the full records that you reviewed in this case from which the unredacted statements arise. So for every page that has unredacted statement, we request the accompanying full record that it was contained in so that we can fairly assess when the statement was made, the context of the statement, to whom it was made, and then figure out how to use it at trial effectively. We would also respectfully ask, Your Honor, that anything that's already been released to us in an unredacted form, and I apologize if I'm just confused on the sealing order, we're not going to disseminate it, we're going to respect the court's order, but is it the court's understanding that when we submit it to you, we're also submitting it under seal, or if we utilize these enclosures, we're submitting them under seal as well?
I'm not following you, counsel.
So I believe your sealing order for the unredacted portions that you released to us, you stated they have to remain sealed.
They will be sealed in the record of trial.
Right.
Sure.
When we utilize them and submit them, for example, we've appended them to some of our enclosures here. Should they be sealed back to the court, or are they unsealed records now because you've already ruled that the Constitution requires their release?
I understand.
And we don't mean to put you on the spot if the court needs to. I know it's a delicate issue, and everybody's trying to be cautious with them. So
Again, you're stating that there will be other filings which you're going to attach to this to the record?
we referred to them today, for example, and we've cited, I think it's Appellate Exhibit 164 in support of our competence motion, evidence exam, and Dr. McDonald, et cetera. We obviously need to utilize them at trial. We want the appellate court, God forbid, to be able to access those without unreasonable.
I mean, that's the appellate court will have access in accordance with the sealing order. I think if I am getting these documents, you can use them, counsel, in trial. I've released them to you.
And that was our only confusion, because the order says that they remain sealed, and so as long as we're able to use them, and I don't mean that, appellate counsel...
Absolutely. And then when it's all said and done in a record, then we're going to seal them again until...
Yes, sir.
With the appropriate folks having access in accordance with the sealing order.
Yes, sir. And I just want to double check. Okay, I believe that's it, Your Honor.
Okay, Lieutenant Callahan, do you want to respond to the request for the court to provide the unredacted records?
Yes, we would obviously object to that. We would request at minimum this would be procedurally done under MRA 513. We made your determination about what has been constitutionally required. I would also seek clarification regarding admissibility at trial versus the discovery request for the review of those records.
Yeah, we're not going to talk about admissibility at trial today. There may be several reasons why they may become relevant, and that's admissible at trial. But clearly, my instruction to counsel on these records are, if you feel that has become an issue, we're going to discuss that again in an closed Article 39A session, and I'll make an appropriate ruling at that time. So, Lieutenant Callahan, I didn't mean to cut you off. Do you have anything else to add?
Nothing further.
Okay. So, in response to your oral motion, I am denying your oral motion. In accordance with MRE 513, I had decided that an in-camera review of these records was required. I have conducted that in-camera review, and I had made a determination that the redacted portions contain only the portions that are constitutionally required. You have what I deem to be constitutionally required. The unredacted I deemed remain privileged, and therefore are not required for me to turn that over. I've made my determination. I'm still charged with scrupulously honoring ME's mental health records, and I have done so. And what you have is what I felt that you needed in accordance with this court's 513 ruling that I issued on 14 September. Okay, counsel, anything else?
Thank you, there's nothing further from here.
Nothing from us, sir.
Okay, counsel, thank you. It's been a long day. Thank you for hanging in there. I do have one other thing to put. I promised you a ruling on Ms. Wong. I'm making the following oral ruling. I find that the defense has met their burden in establishing this necessity of 35 hours of pretrial preparation of Ms. Wong. I am ordering the government to fund an additional 25 hours for Ms. Wong to conduct her pretrial preparation. and I expect that the government, if you need this in writing, I'm happy to provide it, but I don't think you do. I find that necessity has been established here based on the evidence provided by the defense, and therefore I am ordering an authorization of 35 additional hours for Ms. Wong. Also, in addition and in relation, regarding the motion to compel discovery, the one line item surrounding the original documentation that is in possession of CJIS right now, I'm ordering the government to prepare for a custody chain to be established, for that to be delivered to Ms. Wong so she can begin her preparations and her review of that document. And I'm making this ruling today, Council, to continue as we get near the holidays and as we get near, near trial. I want that process to begin as soon as possible. Lieutenant Commander Newstead.
Yeah, I think I just want to clarify. It's one line item, but there's two documents that they have actual possession of right now and one that they're still looking for.
Okay. So again, what you have in your possession, that needs to be sent to Ms. Wong. You need to look for the other document, provide the answer, and if you find that document, the originals will also go to Ms. Wong. Trial counsel, any questions for the court?
No, thank you, Your Honor. We'll comply.
Okay. All right. Hearing nothing further, this court is in recess until 0900 on 19 January.
All right.
Carry on, please.